Hello everyone, and apologies we're a little bit late coming onto the webinar. Welcome to our next in a series of GDPR-focused webinars. Vin Banj, who often chairs, is away on business today, so it's me, Chris Jeffrey, stepping in with two of my colleagues, Debbie Haywood and Katie Knowles. For those of you who don't know us, Taylor Wessing is a global full-service law firm with 22 offices in 19 countries and a real focus on data and data protection in each of those geographies. A quick plug, if I may, for our global data hub. I think you'll find this a really useful resource on the many changes which are happening in global privacy at the moment, including the GDPR, but not just the GDPR. We focus on developments in Asia and North America as well. And then another tool that we released quite recently, some of you may have seen, we've had some very nice feedback on, is our Global Data Protection Guide, which is an online tool which gives a really useful snapshot of the basics of privacy law in over 65 countries, and that's really worth a look. Very quickly on the presenters, my name is Chris Jeffrey. I, for my sins, head up the technology and privacy team here at Taylor Wessing in London. I'm joined by Debbie Haywood, who's a senior professional support lawyer and our guru on all matters GDPR, and one of our associates, Katie Knowles, who's leading on many of our GDPR projects. I won't spend time on the agenda. Because we started a little bit late, let's get straight into the meat, because we've got quite a lot to talk about today. Key takeaways, understanding that some of you will be doing other things as you listen to a webinar like this and may get distracted. The really key takeaways on commercial contracts and GDPR for me are first, that the GDPR is much more prescriptive about what a commercial contract under which EU personal data is shared must contain. And I always think about them being in three buckets. One, when a data controller is appointing a data processor. Two, when a processor is appointing a sub-processor, think data center, think any kind of support provider sitting behind a vendor. And third, data sharing between co-controllers. Now, Debbie will take us through a summary of all three, and when Katie and I talk through some of the pain points, we'll be focusing on those controller-processor and processor-sub-processor contracts. Out there in the real world, in the marketplace, vendors and customers in the EU are pushing out their standard GDPR-ready contracts now. Obviously, the law doesn't come into force until May of 2018, but even an annually renewing contract will flip over once the GDPR is in force. So commercial relationships where data is shared are typically done now under templates which are as GDPR-ready as they can be. I say that because although we have sufficient detail in the GDPR itself to have a sensible commercial negotiation now, it's important to note that market practice is nascent. Nascent meaning all over the place. And EU controllers in particular are very concerned about managing their risk. Guidance and enforcement will inform the detail next year, but until we have that, we really are in a little bit of a grey area, doing our best to close deals for clients and achieve compliance with clients against the background, of course, of a much more prescriptive piece of legislation and the threat. How real it is we will see in due course, but the threat of those very high potential fines. I think it's important to note, just before we get into the meat, and Debbie takes us through the requirements, to note that the contracts are part of a wider GDPR compliance project. They're not the whole GDPR by any means. And when you're thinking about how you will approach, whether you're on a controller or the processor side, or actually you perform both roles for different data flows, you need to identify and categorize who you share data with and who you receive data from. You need to include the new GDPR processor obligations, and you need to ensure a whole piece of governance and process and training and documentation is in place to the extent you can, because many companies are not going to get there, but you certainly need to hit those main GDPR points by May of 2018. And with that, I will pass over to Debbie.
Thanks, Chris. I completely agree with what Chris has said, and that's why I'm going to start by looking at the big picture before we get down into the detail of what the GDPR says on this issue. Because GDPR compliance really is about more than just complying with the letter of the law, and regulators are going to be looking at whether you're complying with the spirit of the law as well. Paying lip service just isn't going to be enough, but complying with the spirit of the law may well help you with regulators if things do go wrong. So I just want to start by reminding ourselves of the data protection principles. While they don't relate to the detail of what you need to include in your contracts, they are the heart and soul of the GDPR, and they should inform everything you do in relation to data protection. So if you keep them in mind while you're drafting and negotiating agreements, you will find it much easier to ensure GDPR compliance. The first principle, 5.1a, that data must be processed lawfully, fairly and in a transparent manner, is primarily the concern of the controller, but in order to comply with it, the controller needs to ensure flow down in contracts. Where the controller has an obligation, which a processor or joint controller will assist with, the contract should deal with this. And recently published ICO draft guidance, very recently, in fact last week, provides a checklist that you can use to help you capture all of these points. The remainder of Clause 5.1 is a useful reminder of issues your contracts will need to deal with clearly. They talk about responsibility, process and liability, and you need to think about them and deal with them in the contract. So these include data minimization, that personal data processing should be limited to what is necessary in relation to the purpose for which it's processed. Accuracy, the data has to be accurate and kept up to date, with inaccurate or out-of-date data being deleted or changed as quickly as possible. Storage limitation, this is about making sure that individuals are not identified for longer than necessary in relation to the purpose for which the data was originally processed, subject to certain exceptions. Integrity and confidentiality, that's about data security, keeping the data secure and preventing unauthorized access or processing by using appropriate technical or organizational methods. Now, this is a phrase which is repeated at regular intervals in the GDPR, and it doesn't tell you an awful lot about what is expected. But finally, you have the accountability principle. You not only have to comply with your obligations under the GDPR, you have to be seen to comply. You have to be able to demonstrate compliance, and being able to point to a compliant contract will be an important part of this, although obviously it's only going to help if you're actually complying with it. You also should keep in mind the concept of privacy by design and default. The idea behind this is that you embed data privacy into all areas dealing with the processing of personal data, and that's going to include your contracts. So the principles act as a guide, but they don't give you the full story. For example, other major elements you need to deal with in contracts are giving effect to data subject rights and covering off liability. In the draft guidance, the ICO says indemnities must be clear, and also recommends the contract make clear that it's the controller who controls what's happening to the data. It's worth noting here that the GDPR explicitly says that if you act like a controller, you will be treated as one, no matter what you are called in the contract. Finally, the ICO also recommends that the contract state expressly that nothing in it relieves the processor of its direct responsibilities and liabilities under the GDPR. So much for the spirit of the law. Let's look at the letter of the law. What does the GDPR actually say you have to include in your contracts? The GDPR has specific requirements in relation to joint controller, controller to processor, and processor to sub-processor arrangements. In relation to joint controllers, a joint controller relationship is one where two or more controllers jointly determine purposes and means of processing. Article 26(1) of the GDPR requires joint controllers to identify their compliance responsibilities in, and I'm quoting here, a transparent manner. A formal contract isn't the only way to do this, and the GDPR only talks about having an arrangement in place, but the addition of the transparency requirement does suggest that writing this down is going to be the best way to comply. And it's also worth bearing in mind that the essence of the arrangement also has to be made available to data subjects. The GDPR is fairly precise about what the arrangement needs to cover. You have to set out the respective responsibilities for compliance, in particular as regards exercising the rights of the data subject. You have to set out respective duties to provide required information to data subjects, and the respective roles and relationships of the joint controllers to the data subject, including who gives them that information. Although note that the data subject has the explicit option of exercising their rights in respect of and against each of the controllers. And this means you should negotiate and document contractual liability between you, something that Chris and Katie are going to talk about in more detail in a minute. The controller is under an obligation to use only processes providing sufficient guarantees to implement appropriate technical and organisational measures in order to meet the requirements of the GDPR. This means that the controller needs to carry out due diligence in the appointment process. Now, while that doesn't expressly introduce specific contractual requirements, it will help the controller demonstrate they've complied if they cover off risks in the processor contract, especially anything particular to the processor which may have come to light during the process. As with so many areas of GDPR compliance, documenting what is going on is one of the keys to demonstrating accountability, and commercial contracts are no exception to the rule. The GDPR requires a contract between the controller and processor unless the processing takes place under a binding EU or member state law. But you should remember that for the purposes of the UK, the ICO has said it will almost certainly be a contract that's required. And at this point, the GDPR becomes highly specific. The contract must set out at least the following: the subject matter of the processing, the duration of the processing, the nature and purpose of the processing, the type of personal data being processed, the categories of the data subject, the obligations and the rights of the controller. So what this really means is that contract has to spell out in some detail the data processing activities which are being contracted out to the processor. And even that is not the full extent of it. The contract also has to place a number of obligations on the processor and require the processor to process the personal data only on the documented instructions of the controller. And note the use of the word documented. This doesn't necessarily mean you have to cover all the instructions in the initial contract, but it may be useful to include a process for providing further instructions. For example, who's authorised to give them, to whom do they need to be sent, and how quickly they may need to be acted on. The GDPR singles out data transfers in particular as an issue on which the processor must contractually agree to adhere to the instructions of the controller. Appropriate confidentiality obligations in respect of persons authorised to process personal data need to be included. The processor has to agree to comply with the security obligations under Article 32 of the GDPR. The processor needs to agree to only appoint sub-processors in compliance with the GDPR, and we'll be talking about that in a minute. Taking into account the nature of the processing, the processor will assist the controller by appropriate technical and organisation methods, there's that phrase again, insofar as this is possible, for the fulfilment of the controller's obligation to respond to requests for the exercising of data subject rights. And again, this is a fairly vague provision, which we're going to talk about more in a minute. The processor has to assist the controller with its security and breach reporting obligations. Again, this is supposed to take into account the nature of the processing and the information available to the processor, so it's not a blanket obligation. The processor has to comply with deletion or return requests by the controller at the end of the contract, assist with accountability, allow inspections and contribute to audits, and deal with the processor's obligations in relation to appointing sub-processors. Now, it's not a requirement that you have to deal with liability issues as far as the GDPR is concerned, but for the first time in EU law, data processors will have direct liability to data subjects in relation to certain GDPR breaches, and they can be fined by regulators. So as a result, all the parties are going to have an even greater interest in ensuring contractual liability is dealt with in the way that is most advantageous to them. Finally, we need to touch on what the GDPR says about the appointment of sub-processors. A processor may not appoint another processor without prior specific or general written authorization from the controller. Where the controller gives general authorization, the processor needs to update the controller about any intended changes to sub-processors and give the controller the opportunity to object. The controller-to-processor contract needs to deal with this. And it needs to discuss whether authorization is going to be general or specific, and how the notification and approval processes work in the case of a general authorization. A processor also has to ensure that it has a written contract with any sub-processors, or that the engagement is covered by a legal act. The contract has to impose the same obligations on the sub-processor as the processor has under its contract with the controller, including, you've guessed it, securing sufficient guarantees that the sub-processor will implement appropriate technical and organizational measures in such a way that its processing will meet GDPR requirements. Under the GDPR, the processor remains liable to the controller for the performance of the sub-processor's obligations. Again, that means the allocation of contractual liability will be of vital importance between the processor and any sub-processors. It's worth noting at this point that as yet there are no standard approved controller-to-processor clauses or processor-to-processor clauses under the GDPR, although there is scope to introduce these, but at the moment there's no easy fix. A crumb of comfort is held out on the understanding that their adherence to future codes of conduct may be used to demonstrate processor compliance. And you never know, these may give more clues on what organizational and technical measures are going to be appropriate in different circumstances. We're also expecting ICO guidance to give us more help on this issue in the future. But bearing that in mind, I'm going to hand over to Chris and Katie, who are going to talk in more detail about drafting and negotiating these types of contracts.
Okay, thanks, Debbie. Identity crisis may seem like an odd title for a GDPR talk, but the point I'm making here is that the specific requirements for contracts of the GDPR really force platforms and vendors to think about whether the way they process data through their platform is really purely with a processor hat on, if I can use that phrase, or whether they sometimes do so as a controller, bearing in mind this is still largely their customers' data. It is harder to fudge that distinction than it is under the current directive. Now, for many platforms, it's not a problem. It's pretty clear, and you don't need to agonize about whether you fall into the controller or the processor category. But for a lot of SaaS platforms, and I mentioned there on the slide digital advertising and big data, but actually when I thought about it, I think practically every SaaS platform that we act for will do analytics to improve the platform, often using live customer data with unique anonymous IDs attached. Now, the GDPR, with an expanded definition of personal data, would hold that data to be personal, and because its analytics are not really done for the benefit of a specific customer, it's likely the platform acts as a controller. So just that flag, it happens at the moment, but a lot of that happens under the radar. I think the answer largely is, and of course it's very fact-specific, the platforms need to be probably more open with their controller customers about that use. Not least because, if you look through Article 28 that Debbie was talking about, every processor contract has to oblige the processor to delete personal data at the end of the relationship, and that typically doesn't happen for this analytics use. That's all I'm going to say on that, so we have time to go through everything else.
And we thought that a very useful way of walking through the various issues that the GDPR presents for controllers and processors and exploring drafting tips would be to present both sides of the argument. So I'll be speaking on behalf of controllers, typically large EU corporates operating in financial services, retail, tech and luxury brand sectors, and Chris will have his processor hat on. So staying with Article 28.1 for now that Debbie mentioned, this really provides the backbone of the controller-processor relationship in stating that controllers should only use processors providing sufficient guarantees to implement appropriate measures in such a manner that the processing both meets the requirements of the GDPR and ensures the protection of the rights of data subjects. So what does this mean for contracts? And here we're not just talking about processor guarantees in the context of security, which is important and we will cover. Rather, it's pointing to pre-contractual inquiries and due diligence. And as Debbie mentioned, controllers will need to assess the adequacy of their processes at the earliest stage possible, well before negotiating the contract, almost as part of a data protection impact assessment. And in putting a service out to tender, as controller, you may wish to rely on due diligence questionnaires, FAQs, minimum security criteria to enable you to compare your suppliers. And your assessment should naturally take into account the nature of the processing and risks to data subjects. So this article sets the due diligence bar higher and is a reminder that pre-contractual inquiries are just as important as what is written in black and white. I've worked on a couple of deals for clients in the financial services and retail sectors recently that involved the outsourcing of their internal HR databases to third-party cloud providers. And the risk here, of course, from a privacy perspective, is high as we're talking about sensitive data and data subjects potentially spanning numerous jurisdictions. And in both cases, the due diligence stage went on for months to enable us in the legal team to do an effective gap analysis of their credentials and feedback to the business. The ICO guidance that Debbie mentioned makes it clear that as controller, once you have chosen a suitable processor, you must put in place a contract which meets all the requirements of Article 28.3. So these two stages of finding a suitable processor and documenting the relationship are separate and distinct. I wanted to touch just briefly on the issue of warranties regarding compliance with data protection legislation, as this is an issue that does sometimes arise. So the vast majority of services agreements that we see already include a mutual warranty that both customer and supplier, controller and processor will comply with applicable laws, which would include data protection legislation. But processors often insist upon having the benefit of an additional warranty regarding data protection from their controllers. This is nothing new, but controllers are technically not obliged to provide it, and it is not essential for the purposes of the GDPR. Of course, in practice, it is obviously in the controller's best interest to comply with all applicable law, but controllers do not need to expose themselves unnecessarily to processors in this way and provide an additional course of action for breach of warranty.
And then looking at that from the processor's point of view, I think you'd actually make a very similar point. It may feel almost automatic that everyone commits to comply with applicable law. Why on earth would you do business with someone who doesn't want to? But I think you need to be more careful for that from the processor's perspective as well. So I think a commitment to comply with the processor's obligations as a processor under the GDPR would make perfect sense. As Debbie said, processors now have their own direct responsibilities under the legislation. But I do worry sometimes that a more general commitment of compliance with the GDPR full stop could be read as transferring part of the controller burden onto the processor. It's a grey area. There's no case law on that. I also think that because Article 28 is so prescriptive, it requires us as a processor to say, we'll only use the data for the purposes of the services and in accordance with the controller's instructions. We have to say that already. And I struggle to see if we do that and everything else that Article 28 requires, what it is that a processor can do that hurts a controller that isn't already covered. So I would beware as a platform that same general commitment to comply.
So just looking at data security, as part of choosing a processor that provides sufficient guarantees that we keep talking about, controllers will be keen to ensure that they have oversight of their processor's security measures and may wish to vet their information security policies. Given the need to set out the guarantees in writing, we will continue to see detailed security policies annexed to services processing agreements. The GDPR does not change the standard of security required. Rather, as we've said already, it is more prescriptive in providing an extra level of detail about what measures may be expected and how security of data may be achieved, which will depend upon the levels of risk presented by the processing, as is the case under the current law. So what does this actually mean in terms of contractual risk? But whilst it's in both the controller's and the processor's interest to assess their proposed security measures given the application of Article 32, the ICO guidance, the one that was released last week, states that ultimately it is for the controller to satisfy itself that its processors provide sufficient guarantees in this area. And that's right. But the risk in terms of regulatory fines, is arguably weighted against controllers. Under Article 83(4)(a), the ICO has the ability to fine organisations up to 10 million euros or 2% of annual global turnover, so the first tier, for breaches of Articles 28 and 32. However, a breach of Article 5, which includes the integrity and confidentiality principle that Debbie mentioned, that could attract a fine of second tier fines, so up to 20 million euros or 4% of annual global turnover, and that's set out in Article 83(5)(a). Therefore, controllers are still very much on the hook, and as a result, we may see them impose their own security addenda on processes more frequently, given that they are effectively being asked to sign off on the appropriateness of security measures.
And then looking at it from the processor perspective, I guess the key message is to be ready for more due diligence requests from your controllers and perhaps a longer sales lead time, at least in the short term before things settle down under the GDPR. And I know all this sounds like an extra burden and all very negative, but I also think there's a sales opportunity there for the processors who get this right. I've just come from a session with one of our platform clients looking at doing just that, looking at playing how their platform, which amongst other things does focus on security, is actually a tool to help their controller customers keep compliant. So there clearly is an element of opportunity here. Things I would be ready for, though, as a processor generally, is to preempt some of those customer concerns around security with your own FAQs, white papers, maybe a draft privacy impact assessment, even though that's technically only a GDPR requirement on the controller, and to use those to show A, that you understand your controller customer's problem and that you're sympathetic to it, particularly if you're not a European headquartered company yourself, and B, that you've already taken steps. Now, they may not think they're enough, they may have lots of questions to ask, but again, you've taken steps to move them much closer to GDPR compliance. I think that psychological comfort factor can be an important one. Where the GDPR goes further and has something different to say about security that you need to bear in mind is it mentions specifically pseudonymization, it mentions encryption, but that's on most people's radar already, and the need for backup and disaster recovery, and not just what is sometimes the narrower security concerns around firewalls and password protections and that kind of perimeter security, if you like. Because the GDPR mentioned those elements, you need to play out those elements in any paperwork that you try and put in front of your customers. Now, Article 28, as we've heard, requires the controller to sign off on the appropriateness of the measures taken at the contract stage. So I think that means, whereas some contracts now talk very generically about appropriate technical and organizational measures, as Katie was saying, expect them to be specific. And Katie's absolutely right. A lot of controllers will have at least their own template bunch of security steps. But because we're the processor and it's our platform, we need to preempt those as much as we can. But we take the security steps that we take, if you like, and we should be clear about those, put them through a GDPR filter, but present those in our template MSAs and data processing addenda.
On the subject of sub-processing, the current rules simply apply the common contract law provisions on subcontracting. However, in practice, many arrangements have interpreted the current directive as requiring sub-processors to be appointed on the same terms that apply to processors and subject to controller approval, particularly in heavily regulated sectors such as financial services. Consequently, the requirement under Article 28(4) for processors to flow down the same terms to their sub-processors and remain liable for any breach is unlikely to make much difference in practice, as this is what many controllers have been insisting upon to date. Of course, where the GDPR expressly differs from current law is in the ability for controllers to give general authorization to sub-processing, as Debbie mentioned. Of course, controllers may still insist on the requirement for consent at all times to keep maximum control over the supply chain. But where they do decide to give general authorization, and we have seen this, they should think very carefully about how to document what would happen in the event they wish to object to a change in processor. And there are a number of ways of exploring this. And the way we sometimes provide for this is to allow say, the parties to explore changing the services in a way that would avoid the use of the proposed sub-processor. And where this is not feasible or the changes are not carried out within a specific time frame, the controller is then given the ability to terminate the contract with immediate effect. And that termination could apply to the contract in its entirety or the part that relates to the affected services, on the basis that both parties walking away from a deal may not be the preferred solution. Again, in terms of drafting, the GDPR creates a specific subcontracting regime in relation to processing, as currently the appointment of another processor is treated in the same way as any other subcontracting. So this may result in two clauses appearing, one for data processing related subcontracting, and the other for other types of subcontracting. The important thing to bear in mind is that the two types of subcontracting must exist alongside each other, however they're documented.
And then from the processor view, flipping the coin over, of course the real challenge here is this is one of the areas where it feels like the GDPR is living in a completely different world from the way technology certainly is supplied these days. As the world moves into the cloud, one of the beauties of which is the efficiencies driven by having the same vendor base, data centers, support providers, call centers, wherever it might be. The notion that a customer or a group of customers can veto you changing one of those is clearly a real challenge to processors. Now, as Katie and Debbie have mentioned, that specific or general consent is clearly that the processor community are focusing very much on the general authorization, as you would expect. And when you look at what many of the really big sub-processors